Anne-Marie. Anne-Marie, good morning, ladies and gentlemen. Thank you very much for attending this press conference. My name is Eric Cardall, Kaardal, and this is Anne-Marie Calgaro, my client. And we're going to organize the press conference of a series of speakers, myself introducing the lawsuit, then Anne-Marie is going to speak, and then Michelle Lentz, representing the Child Protection League, is going to speak, then Mr. Breccia, and then Representative Glenn Grunhagen, so you won't be surprised. The lawsuit that we're filing right now in the U.S. District Court is a federal due process clause claim, and what Anne-Marie is the mother of a minor child who, without her consent and without court order, has been able to get government funding for an elective medical procedure from Park Nicollet to change his identity, JDK's identity, from boy to girl. In the statute in play, Chapter 144, it's cited in the complaint that I've distributed, it's 144.341, allows medical service providers to determine emancipation without reference to parental consent or court order. That's very important to understand. This is a controversial law that was passed in 1971, and in 2003 and 2004, the House tried to repeal this law under the Parental Health Access Act. So the idea here is that one side has said we're not going to have parental notice and opportunity to be heard, and the other side has, and the statute still exists, so medical service providers determine whether a teenage child is emancipated and then can get these non-emergency elective medical services. And Anne-Marie's upset about it. She still communicates with her son, but she doesn't have any right in court. So if you'd imagine, Minnesota has statutes that codify due process procedures in marital dissolution, in child protection, and in paternity cases. But this is the emancipation subject area, and there's no statutory procedures to protect the parental rights. Now, on the judicial website, you'll see that the court says if you're a teenager, you can file a common law petition for emancipation. Well, that's fine, but here JDK didn't need that court petition for emancipation because the governmental agencies here, the school district, the county, other state agencies, just treat him as emancipated anyway. So if there had been a court order of emancipation, then Anne-Marie would have received notice and opportunity to be heard. But here, because of the way the county operates, the way the state operates, the way the school district operates, the way the medical providers operate, Anne-Marie doesn't have any right to notice and to be heard in court. So how does that operate practically? Well, Anne-Marie has been shut out of all educational and medical decisions for a child and can't even get information from the medical service providers, the county, or the school district about her child. That's all without a court order. So the statute that I mentioned doesn't provide a process for Anne-Marie even after the deprivation of her parental rights to go to court. Now the common law, that's the ancient common law, provides her child an opportunity to petition for emancipation, but of course the ancient common law doesn't recognize Anne-Marie's right to petition to de-emancipate the child. You see the asymmetry there. The common law is old, and the common law has been around for a long time, and the child can petition for emancipation under the common law, but there's no common law right for a parent to come back and de-emancipate the child. So the statute is unconstitutional in its application to Anne-Marie because it doesn't provide a procedure that when the medical service providers in the county decide to treat the child as emancipated, for Anne-Marie to file a petition in the court. She is not getting her day in court. This lawsuit isn't about, in a sense, the parental rights themselves. It's about a day in court to defend the parental rights. And that's huge. And in Minnesota, we're a very conscientious state, and when it comes to petitions for emancipation, the courts say right out in the opinions, well, emancipation for teenagers, that can be conditional, it can be partial, it can be temporary. So what the judges are saying is, we want to take care of the best interest of that child. But how does that happen when there's no court procedure at all? Anne-Marie has lost complete control of her teenage son without any court proceedings, any court hearings. And because of Minnesota statutes and common law, she can't even go to state court. If she went to state court, there's no claim. She can't do anything. So what we need is a federal court decision saying that Anne Marie's federal due process rights have been violated because her parental rights are a fundamental rights protected under the U.S. Constitution, and she's entitled to a hearing prior to her parental rights being terminated by the county, the medical service providers, and the school district. I'll be available for more questions, but now I'd like to introduce my client, Ms. Calgaro.
Hi. My name is Anne Marie Calgaro, ANMARIECALGARO. Last year, without my knowledge or consent, without any court hearings or legal process, without any involvement on my part whatsoever, a legal aid group that gives free services to low-income people created a notice of emancipation for my 15-year-old son. Suddenly, my son, without any notice to me, was no longer under my supervision. Based on that piece of paper alone, he began receiving public assistance, including medical services and housing and food support. The St. Louis County Health and Human Services treated him as an adult. I couldn't get any information regarding my son. Even the school refused to allow me access to his records. It was then brought to my knowledge that my son had begun receiving hormone replacement treatments from Park Nicollet Health Services to transition from male to female with medical assistance paying for this. Excuse me. I was not consulted or informed about this in any way. I had no way to give or receive any information about my son. Since then, Fairview Health Services of Hibbing has also prescribed narcotics to my son. I am forbidden to be involved with his very important health needs. The news that county agencies and health service providers, the school and other county and state offices were completely bypassing me came as a complete and total shock. Why wasn't I even notified? I believe that my constitutional civil right to have my case heard in a court of law has been stripped from me. If this had been a child custody case, I would have had my day in court. If my son were to be placed in foster care, I would have had my day in court. Or if he had been referred to child protection, I would have had my day in court. I am firmly committed to what is best for my son. I am his mother, and he has always been and always will be welcome in our home. He has 3 older siblings and 3 younger siblings whom still live in the home, not the older siblings. And we all love him beyond words and care very, very deeply about his well-being. As a mother, I know his emotional and physical needs in a way no one else can. I also have a commitment to him that no one else has. And I feel not only was I robbed of the opportunity to help and guide my son make good decisions, but I also feel that he was robbed of a key advocate in his life, his mother. I'm taking this action today so that the courts will recognize my due process rights under the United States Constitution. And so for that the good of my son, the courts will restore my parental rights. I'm also taking this action for the benefit of all parents and families who may be facing the same violation of their rights, so that they and others in the future may be spared from the same tragic events. Thank you.
And now I'd like to introduce Michelle Lentz. She's a representative of the Child Protection League.
Thank you, Eric. My name is Michelle Lentz. I'm the president of the Child Protection League, MICHELELENTZ. The Child Protection League exists to protect children from indoctrination, exploitation, and violence. CPL is eager to support Anne Marie Calgaro in her legal challenge to the grievous assault on her parental due process civil rights protected by the 14th Amendment to the U.S. Constitution. We're grateful that she's willing to take this bold step because she gives voice to the countless parents and families across the country that are being similarly harmed. St. Louis County Public Health and Human Services, Park Nicollet Health Services, Fairview Health Services of Hibbing, and the St. Louis County School District have essentially eliminated Ms. Calgaro's parental rights based on nothing more than a statement of emancipation issued by the Free Services of a Legal Aid Group and without any court order. These entities are treating this now 17-year-old minor as if he is an adult. They are financing and prescribing dangerous hormonal drugs and prescription narcotics to a minor without his mother's knowledge, involvement, or consent. She is blocked from even viewing his health and school records. For his safety and for his welfare, Ms. Calgaro wants and needs to be involved in the ongoing medical care and education of her child. She is denied any avenue to plead her case in court. Children are too often being used as pawns for the financial and political designs of special interest groups, groups that cannot have the level of regard for the personal, long-term well-being of a child as does a parent. Government agencies and health care providers should be protective buffers for minors. They should never be a party to violating the rights of a parent to oversee the needs of her child. The decisions underage children make about themselves often have permanent consequences that will affect their relationships, their families, their health, and their emotional stability. And yet, the very person who knows, loves, and is most deeply committed to her child is being excluded from providing for him at this hour of his greatest need. Few values are more sacred and more deeply regarded than the nurturing bond of a loving parent-child relationship. Disregarding and trampling that bond severely harms children and families. CPL urges the court to declare that Ms. Calgaro's due process rights under the U.S. Constitution have been violated and to issue an injunction restoring her full parental rights under her due process until her due process rights have been restored. We encourage, support, and defend Ms. Calgaro's courageous lawsuit. She deserves everyone's respect, admiration, and support. It may have enormous implications for all families and children. Thank you.
I'm pleased to announce that we have a special guest for the press conference today. Coming from Chicago just for this press conference is Tom Breccia, President and General Counsel of the Thomas More Society, a public interest law firm.
Oh, thank you, Eric. Our Thomas More Society is a national public interest law firm. We are pleased, honored to support Anne-Marie Calgaro and to work with Eric Cardall here. He's an excellent lawyer. We're here to help him, back him up, and press this case until justice is achieved. And that's really all I have to say. Thank you. We're in this for the long haul. Bye-bye.
And our final speaker, and then we'll take questions, is Representative Glenn Gruenhagen.
Thank you, Eric. I'm State Rep Glenn Gruenhagen, and as soon as I get to my notes here. As an elected official, I am deeply concerned when I see state agencies, healthcare services, and other organizations undermining parental authority. I intend to introduce legislation to strengthen parental authority over their children and to make sure that it cannot be undermined or negated.
But I have an opinion on that, is that I've done a lot of research in this because I care so deeply for my son. I want to be involved in this process, is that I've learned that for those kids transitioning, if he changes his mind in the future, these, and not that he will, and that's not what this is even about, but to answer your question is that if he did change his mind and he wanted to have a family of his own, some of the side effects of these hormone replacements are that he would become sterile and he would not be able to have a family of his own. And I guess, you know, with the FDA, they do a lot of research on the certain medications that are prescribed, but I think that was lacking in this sort of area of the medical field. And so he himself has described to me that the hormone replacement has caused him to feel suicidal, that it's caused him to feel very crazy at times, and the doctor reiterated to him that's perfectly normal. You're like a little girl going through puberty is what they told him. And they also told him that the best time to do this is now before you are completed with puberty, which I disagree. I'm not saying he should be one way or the other. I'm not pushing that. I love him unconditionally, and I mean that unconditionally. I just wanted him to slow down and let himself develop naturally and see if he still felt the same way at 18 when he is a legal adult as he did at 15. And so that's the best that I can do in answering that.
How does he feel about this?
He knows about this. We've asked him to be a part of it, and his only fear was that he would lose his treatments. He understands it completely. He agrees, Mom, you should have had a day in court. He agrees with that. And he also agrees that he received bad legal advice, but he also says, well, it's working. So, I mean, a typical 16-year-old response, I think. So, yeah, I think that I think that he's experiencing confusion from all over, not just this one thing. I think that when we went through puberty, I think we were all a little bit kind of crazy and confused. But, yeah, that's the best I can say. He's got his own apartment.
How long has he had his own apartment?
It's probably been, I'd have to look at my notes, 6 months, something like that. We've helped him get furniture for it. You know, I don't approve of him living on his own, but when I went to visit him, I'm kind of like, well, you need some stuff here, you know. And so we got him some furniture and some dishes and things like that. So I love him, and you know, at his apartment, it was all white walls. There's nothing. I'm like, this kind of, except for the padded walls here, we really need to get you some life in this apartment. So we're working on doing that. I have family members who have helped get stuff for him just to help him.
And he's been out since he was 15 or out of the house since?
No, he was 15, yes. He went to live with his dad. His dad and I are not together. We had two boys together, and because he's intelligent. My son, JDK, is extremely intelligent. I would not deny that on any level. He excels very much in academics. And with what he was going through, he wanted to go to a different school. He wanted where there was more educational opportunities for him. And after some lengthy discussions and agreements, I agreed to let him go live with his dad. And in that process, this all sort of took place, and Dad moved, and he was kind of...
Did his father have any part in
No,
this, or in him becoming whatever kind of emancipated he is?
he very much objects to this, and he's in agreement with me that we should have at least had our side of it heard. I mean, I can't imagine taking anybody's one side of a story. We should always be seeking to find, you know, I always say that there's her side and there's his side, and then somewhere in the middle is the truth, right? Because we're all persuaded by our own perception of what we believe and how we feel. And so he just agrees that we should have been heard.
Since you've been involved in this, have you talked to other parents in similar situations?
You know, I'm not finding anybody in a similar situation, but I do talk to other parents. I'm very involved in the community. And with the transitioning thing put aside, because that's not even the issue. The issue is that he's able to just go make these decisions, and then, well, what stops anybody else's child from doing the same thing? You know, maybe somebody wants to go get emancipated because mom says you can't have a tattoo, but they want a tattoo. You know what I'm saying? And so they agree very strongly and are fearful that this could happen to them, regardless of what their child may be going through.
Representative, as a former school board member, which I've heard you say a few thousand times, have you seen examples of something like this happening in schools where they consider a student emancipated without a court order?
Yeah, repetition is the key to learning. That's why I repeat that so often, okay, about being a school board member. There's certain incidences, I don't want to go into specifics, but I haven't seen specifically an emancipation letter, but there is sometimes referrals for medical treatment without parental notification, and that is a concern. That was a concern of mine, was on the school board, and it continues to be as a legislator. Again, I don't like to see the undermining of parental authority without any type of due process legal procedure. So, and that's, I guess, the root of the situation.
Have you seen, I guess what I call an elective medical procedure, like whether it's this or something else, happen without an emancipation order?
No, I haven't.
And Eric, I have another question for you. Sure. Has a similar case come up in federal court, since that's what you're looking at here, and if so, how did it turn out?
No, we haven't found this particular fact pattern. And I think the distinguishable facts are just the major non-emergency elective surgery statute that doesn't require parental notice and consent, and the common law not providing the parent an opportunity to petition to get the rights back. I did want to mention that the Mid-Minnesota Legal Aid Clinic letter is Exhibit A. B is the St. Louis County court order, which was a response to an earlier question, which states that you can't change your name because you don't have a court order of emancipation. So again, the court's recognizing that notice and opportunity to be heard is required for the parents prior to emancipation. And then C is the letter from Park Nicollet Gender Services, which was presented by JDK in support of the petition in St. Louis County to change the name. So that's how we got it. And so that letter is from Dr. Julie Farias of Park Nicollet Minneapolis Gender Services, indicating that the treatments are being provided. So, and so I just wanted to mention that those exhibits are included. Are there any further questions?
And to be clear, besides the gender change, did I understand, I think you said that the county has authorized payment to help him live by himself?
That's right. The county determined that he was emancipated, meaning that he was eligible for the programs. So, for example, how the insurance works is if Anne Marie had a chance, she would have said, well, he's covered under my insurance policy. The government shouldn't cover it. Then, of course, her consent would be required for the services. And so here, the county, by making JDK eligible for benefits like medical services, has enabled Fairview and Park Nicollet to provide these services that she objects to, all without a court order. And so, it's almost like, I was talking to Mr. Brecky about this, it's almost like, okay, he goes to the county says, well, you're independent, you get all this money, and then everyone else acts as if he's independent. But the county never provided notice and opportunity to be heard for the parent. And again, the result of an emancipation proceeding can be that you're emancipated conditionally, partially, temporarily. And so you can have the judge, kind of make these distinctions, which are made every day in the context of child custody disputes. Yeah, he was from Minnesota, yeah. So, and are there any further questions?
Filed in St. Paul or Minneapolis?
And U.S. It's filed. We're filing electronically, and so the U.S. District Court, I guess the division would be Duluth, right? Yeah, but it's the one district of Minnesota and the different divisions.
So that's where any hearings likely would be?
Before the magistrate judge, that's an excellent point, that it's likely to be up there. Yeah.
In regards to this lawsuit, has there been any precedents that would either hinder or help this particular lawsuit?
Well, I kind of did the less is more thing before, so I'm going to respond to this in the greater way. So, yeah, I mean, all the cases say that parental rights are fundamental rights under the U.S. Constitution. They're liberty interests under the 14th Amendment. The 14th Amendment says liberty can't be deprived without due process of law. So all the cases say that prior to termination of parental rights, a parent has a right to be notified and an opportunity to be heard. Now here, because the non-emergency aspect of the medical services being provided, we can even say, we don't get a hearing after the deprivation. So it's been announced that, by the medical service providers, others, that he's emancipated, we can't get the information, can't be involved, but there still isn't a process even after the deprivation to go to state court. So, yeah, all the case law runs in our favor, and the statute that we're talking about is constitutionally defective, because it doesn't have a procedure for a parent to go to state court and fight back. Any other questions? Thank you for coming. I really appreciate it.